Good evening, all of you. So yesterday we had covered the first part of Polity PT365. So today we'll be covering some of the other topics continuing from the yesterday's class. So before that, let me just load the PPT. Yeah. So in the last class, we had covered the first part of this polity. We majorly saw in detail about this reservation provisions. We saw the background, we saw the current issues and the current cases related to reservation, and a few of the other things introduced recently, whether it is the reservation related to SC/STs in the parliament or the Anglo-Indian का जो provision अभी remove किया है, and even a few of the ST tribes were also added in the list of STs. Fine. So any doubts in this, whatever we had discussed? Are there any doubts?
Sir, there were some doubts, from the previous class that one of the coordinators had received. They would like to ask few of them.
Sure.
Some of the doubt of the students can be answered by you as well.
Sure. Please go ahead.
Please, Ruchi.
Yeah, sir, there's one question, which is whether that SC/ST thing was ratified by the 50% of the states or not yet. If it has not been ratified, if the question is asked in upcoming prelims exam that whether the SC/STs have the reservation in Lok Sabha, will that be yes or no?
Yes, it is ratified. It was supposed to have ratified before January 25th, before January 25th, 2021. So before that, after that would have got expired, the reservation would have got expired. Now it is ratified.
Okay, sir. Thank you.
Any other queries?
No, sir.
Okay, I hope all the things are clear. So my only suggestion was that before you start to see the next video, please try to revise once, because revision is very, very important in current affairs. Otherwise, it will be too volatile. You will not be able to remember many of the things. अभी के लिए तो आप क्लास में बैठ के जब सुनते हैं या घर पे बैठ के सुनते हैं तो आपको ऐसे रहेगा कि सब कुछ याद है, but unless you revise, you will not be able to remember it in the long term. Fine. Yeah. So let's continue the discussion. So let me just tell you the topics today we are going to cover. So we'll be covering the rest of the topics in the first part, that is issues related to constitutions. We have many of the issues related to the rights, internet as basic right to property, sedition, and then the issue of minority education institutions, and the recent impeachment of Trump, and we're going to discuss all that. And other than that, let's try to cover some of the aspects related to the legislature also, which is in second topic. Now the first topic for today's, let me just take the presentation. Yeah, the first topic for today's discussion would be Internet as basic right. Internet as basic right. Why this is in news? This is in news because the recently Supreme Court gave a judgment regarding the shutdown of internet in Jammu Kashmir after the abrogation of Article 370. Internet was shut down for a long time, very long time, more than 6 months. It was not operated, and few of the people had gone to the court. So in that case, the Supreme Court had given some of the judgments. So before we go to that, let's just see briefly what are the current provisions related to the control or shutdown of internet in India. So to shut down internet, what are the powers? From which provisions of the government, which provisions of the any of the legislature or any of the rules or regulations government is shutting down? Okay, let's just briefly say this. So currently there are three provisions through which the government is shutting down internet. The first one is CRPC 1973. CRPC 1973 is the first provision based on which the government is shutting down the internet, and the second one is IT Act 2000, and the third one is Telegraph Act 1885. Okay, so first one is CRPC 1973, second one is IT Act 2000, third one is Telegraph Act 1885. Okay, let's just see in this detail what exactly is this CRPC 1973. इसका कौन सा provision use करके the government is shutting down the internet. In this there is a section of CRPC, section 144 of CRPC. So many of us have heard about this section 144, that too in the current times. Many of the state governments use this section even to control the mob during the times of corona, to not let the people come out in public in groups. So basically this section 144 is very famous. हम papers में भी पढ़ते हैं what is section 144, section 144 लगा दिया ऐसे बोल के, like we keep reading about this. So what exactly is this 144 section? It is a provision, you can see it is CRPC, that is Criminal Procedure Code. Okay, what is the difference between IPC and CRPC? IPC talks about the definition of crime. It defines crime. What exactly is the definition of crime? It is defined in IPC. But CRPC talks about the procedure for investigation, procedure for inquiring into the case and giving the punishment, and even the term in case of punishment, what exactly is the punishment. Everything is defined in this CRPC. In that section 144 talks about the order to restrict unlawful assembly. Okay, you might have heard about this unlawful assembly. That means the government can say that people more than so and so numbers are not allowed to come out in public. Okay, usually it is said 3 or more person should not come. 4 लोग नहीं आना चाहिए. 4 लोग आ गया तो आपको, like, we can arrest you. है ना? So it is illegal. Okay, it is illegal to come out. ऐसे बोल सकते हैं. But even though it is said, usually it is said as 4 people, it can be restricted even to 1 people also using the same provision. Okay, using the same provision, the government can also say even 1 person is not allowed to come. Who can issue this order? It is the DM or SDM of that particular district, empowered by the state government. Okay, whoever is empowered by the state government, usually the DM and SDM of that particular district, can issue the orders of section 144 under CRPC. Whenever this order is issued, no group of people are not allowed to come out in public. So now how is this related to the shutdown of internet? The government usually uses this order even to shut down the internet. Basically it is saying that कुछ emergency situation हो गया है, so we are not allowing the proper grouping of people, even the communication is not allowing. तो इसके वजह से issue नहीं होना चाहिए, because internet might be used to spread the fake news, spread the messages. तो इसलिए internet को भी हमें बंद करना चाहिए, ऐसे बोल के usually they shut down the internet also. But based on the order of DM or SDM, internet can be shut down only for up to 2 months. Only for up to 2 months internet can be shut down. If the government wants to extend beyond 2 months, it has to be the decision of the state government, that too up to only 6 months. Okay, as per the provisions of CRPC 144 section. Okay, let me just tell you again. Using this provision, that is the prohibitory orders, the government can say that the people are not supposed to come out. In addition to that, the government can also shut down the internet for 2 months and extendable up to 6 months if the state government agrees. So usually this common provision is used by the governments to shut down the internet also. Abhi recently जब issue हुआ था, there was certain issue related to the Citizenship Amendment Act. There were protests in many of the regions. Even the government used this provision to shut down internet in many of the major cities. Lucknow mein, Agra mein, in some parts of Delhi also this provision was used. Second provision I want to talk about is IT Act 2000. So what exactly is this IT Act 2000? It provides provision for various various provisions related to internet, उसको कैसे control करना है, who has authority and all. In that particularly, section 69A talks that the government can block websites. Government can block particular websites and the transmission of messages. Okay, try to see this clearly. It is not the complete shutdown. Complete shutdown of internet is not allowed under IT Act. IT Act 2000 use करके the government cannot shut down the internet, but some of the websites can be blocked. Some of the website can be blocked. This is related to IT Act. The third provision is related to Telegraph Act. Telegraph is the first provision. CRPC 144 section. This is second provision. IT Act. The third provision is Telegraph Act. We have a Telegraph Act which was enacted in 1885. So using the provisions of Telegraph Act, the government had come out with temporary suspension of telecom services rules in 2017. So these rules are currently used to shut down the internet for temporary period. This rule specifically gives the power, okay, it specifically gives the power to the government to interpret or block the message in case of public emergency. This is important. There should be some kind of public emergency. In that case, this provision gives the power to the state government to interpret, tap the communication, or even completely block the messages. Using this provision, the government is also shutting down the internet. ठीक है, अभी तक तो clear हो गया. What are the provisions using which the government is shutting down the internet? Now let's come to this, the Supreme Court judgment which came recently in January 2020. Okay, in January 2020, like after the abrogation of Article 370 in Jammu Kashmir, everything was stopped, the curfew was imposed, even the internet was stopped. So many of the people had approached the court and it was taken up, and finally the Supreme Court said few of the things in January 2020. So what exactly the Supreme Court said? The first thing about the Supreme Court judgment is about Article 19. Article 19 के अंदर there are two important provisions. Article 19 clause 1A, Article 19 clause 1G. Article 19 clause 1A के बारे में तो आपको पता है. It is about the right to freedom of speech and expression. Right to freedom of speech and expression. Article 1 clause G talks about the right to conduct the trade or do one's profession of one's freedom. है ना, जो भी जिनको भी जो भी काम करना चाहिए या प्राइवेट बिजनेस होना चाहिए या if somebody is running the company, that kind of freedom to follow one's profession is there in Article 19 clause 1G. So now how the Supreme Court is linking this to internet? Supreme Court said that Article 19 clause 1A, that is right to freedom of speech and expression, can also be exercised through internet. Fine. That is 19 clause 1A includes the right to freedom of speech and expression through internet also, and Article 19 clause 1G includes the right to practice trade or any kind of profession even through internet also. यहाँ पर भी आप internet के through exercise कर सकता है. So this is included under Article 19 clause 1. So suppose since these rights are included under Article 19 clause 1, so you cannot suppress this for a longer time. But is Article 19 clause 1 completely absolute? No. There are certain grounds on which you can impose the restrictions on Article 19 clause 1. What are the grounds? Okay, we have many other grounds: the sovereignty, security of the state, integrity of the state, morality, decency, public order. ये सारी जो 19 clause 2 के अंदर जो mention है, 19 clause 2 के अंदर जो mention है, based on these grounds only you can suspend it. Of course, this is not absolute, but you have to suspend this. But if you have to suspend any of these freedom under Article 19 clause 2, you should follow these principles of proportionality. Okay, this is established that you cannot absolutely suspend as it is. है ना, at any condition you cannot just give the reason that ये जो national security reason है या public order है, morality है, decency है, उसके reason में हम suspend कर रहे हैं, ऐसे कभी भी नहीं बोल सकते. But it should follow the principles of proportionality. What is principles of proportionality? Whenever you are trying to suspend any of the freedom, you have to remember that for which cause you are suspending, that cause should be greater than the damage it is causing. That means for whatever the reason you are suspending, so that should be in much more bigger proportion than the actual hindrance to the freedom. The people which they are undergoing the suppression, that should not be for a smaller cause. No, that should not be for a simple petty reasons. It should be for a bigger cause. Only in that case you can suspend. So that is what is principles of proportionality. So now aa gaya hai ki like the right to freedom of speech and expression and the right to trade and commerce, which is guaranteed under Article 19, can also be exercised through internet. Now you cannot shut down the internet indefinitely. If you want to do it saying the security reason hai, temporarily kar sakte hai, but not indefinitely, but not permanently. That would violate the fundamental right. So Supreme Court is basically saying that ab jaldi se jaldi internet wapas lana chahiye Jammu Kashmir mein. Okay, so this is one thing. Second thing, section 144 of CRPC के बारे में भी Supreme Court has said. Supreme Court basically says that ये जो section 144 है, so that is imposed on the fear of apprehended danger. Okay, that on the fear of apprehended danger, there should be a kind of public emergency. तब भी आप इसको impose कर सकता है. Unnecessarily आपको impose नहीं कर सकता है. And even if at all you are imposing, you should state the facts. You should state the facts there so that any of the people who are undergoing the suppression can bring this to the notice of judiciary, and that can be checked under judicial review. Fine. Let me just repeat again. Supreme Court is saying that ye jo whatever the order which you are issuing under section 144 of CRPC should be done only in case of some kind of public emergency, and even in that case also you should state the facts so that it can be checked by the judiciary under judicial review and see whether such imposition of 144 is correct or not. I hope this is clear. Yeah. So one more thing in this context, let me just also talk about one of the recent judgment of Kerala High Court. So what happened exactly in Kerala recently is that there was a girls' hostel in one of the city, I think Kozhikode or some city. So in that there is a restriction on usage of internet for the students over there, for the residents over there who are residing in that hostel. So they are not supposed to use internet after 10 o'clock. They are not supposed to use laptop after 10 o'clock. ऐसे कुछ rule था. So some of the students went to High Court, and finally the High Court gave the verdict that the access to internet is part of fundamental right. Okay, the Kerala High Court said that the access to internet is part of fundamental right, so you cannot curtail it. Okay, so I am going to ask a question now. So which part of fundamental right it is? Access to internet is part of which of the following fundamental rights of Indian Constitution? Okay, if any of you have read this news, Kerala High Court ka jo judgment tha, so let's just see if you are able to answer this, whether it is Article 14 or Article 17 or Article 21 or Article 18. क्या हो सकता है इसका आंसर? So answer is Article 21. The Kerala High Court said that the right to access to internet is part of right to privacy. It is part of right to privacy. That means it is part of the Article 21. So you cannot curtail this without much bigger reason. You cannot curtail it as it is because it is going to be violation of right to property. ऐसे बोल के the Kerala High Court has given. Now your doubt may be, अगर Supreme Court बोला है Article 19 का part है, Kerala High Court ने बोला है Article 21 का part है, कौन सा article का part है? So if you listen to this carefully, I had clearly said ये जो Article 19 के अंदर part होगा, it is the Supreme Court did not say that it is about the access to internet. इन आर्टिकल 19 and 19(1)(a) and 19(1)(g के अंदर जो है प्रोविजन दैट इज रिलेटेड टू राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन एंड राइट टू प्रैक्टिस वंस ओन profession, trade, or any other thing related to the profession. Okay, so that freedom is also can be done. That freedom is also can be exercised using the internet. That is what is the Supreme Court had said. In that, the Supreme Court did not say that it is about the access to internet. It is that since there is no internet, it is hindering the Article 19 clause 1A and 19 clause 1G. So इसलिए आपको provide करना चाहिए. What the Kerala High Court had said that if you are suspending the internet completely without any reason at all, that would be the violation of right to privacy. So you cannot do that. In that sense, the right to access to internet is part of Article 21. I hope that is clear. Any doubts?
Sir, we can reduce the speed of the class a little bit. Just
Okay.
to give you the class.
Okay. We'll try to reduce. Fine. Anything else?
No, sir.
Okay. Thank you. Okay. Fine. So I hope this is clear. Internet as basic right. Let me just start with the next topic. Okay, I'll try to reduce the speed. So the next topic is right to property. Okay, before we start with this right to property, let me just ask you a question. Okay, the question is there on your board. You can see that right to property is not a fundamental right or a constitutional right or a statutory right or a human right. Which of the following is not? Any queries?
Sir, is there like if the these basic rights are breached, is there any safeguard against it, like there are for fundamental rights? And what is the basic difference between fundamental rights and the basic rights?
Basic right.
Yes, sir. Like the internet is a basic right, as the Supreme Court has ruled over. So if my basic right is breached, then do I have any safeguard against it?
No. In the Indian Constitution, there is nothing. There is no safeguard as such for the basic right. But for fundamental right, we have the safeguard of Article 32. But as such, basic right is not a very defined right as such. It is basically saying that it is an important right, human right. सबको जो होना चाहिए ऐसे बोला है. Okay.
Okay, thank you.
But right to access to internet is said as part of 21, right to privacy. But expression, freedom of speech and expression through internet is part of Article 19. So even though access to internet is said as basic right, it is indirectly has been made as part of fundamental right.
Okay, sir. Thank you.
Yeah. Now I had asked a question. Right to property is not. Okay. Should not miss this. It is not what? It is not a fundamental right, or it is not a constitutional right, it is not a statutory right, or it is not a human right. Okay, the answer is it is not a fundamental right. It is a constitutional right, it is a statutory right, and it is also a human right. Right? So let me tell why. The topic is the right to property. Why it is in news? Mainly because in the state of Himachal Pradesh, so there was the land was some I think it was around 3 hectares of land was occupied by the government that belonged to a woman over there. So that was occupied by the government for constructing road. Okay, ऐसा ही नहीं था. Yeah, government had the reasons to occupy this, but it was occupied for constructing road, and that happened in 1967. Remember, at that point of time, right to property was also fundamental right. So that woman had gone to the Supreme Court, had gone to the judiciary, and it had reached the Supreme Court. And now finally, recently, the Supreme Court said many of the things about this. क्या है ये जो right to property violation के बारे में क्या करना है क्या नहीं करना है, तो अभी आया है. So it's basically that woman is already 80 years old now. Fine. So that shows the speed of our judiciary. Fine. So before we go into detail about this, let's have some background about this. Right to property. Constitution के अंदर what are the provisions for this right to property? So we have this articles, Article 19 Clause 1F, Article 31. These two articles were there earlier. They were earlier part of fundamental right. Okay, why I'm saying earlier? Because that was removed now. तो पहले क्या था? What was there in Article 19 Clause 1F? We know about Article 19 Clause 1, that is, it is the right to freedom of speech and expression, and Article 19 Clause freedom. It provides for different kinds of freedoms for the citizens. 1A talks about right to freedom of speech and expression. 1B talks about right to assemble. ये सारा बहुत सारा है. In that, one of the freedom is the right to possess, right to acquire and dispose of the property. So basically that this guaranteed a kind of freedom on the people, on the citizens of India to acquire property and dispose of or hold the property. Okay, along with all the freedoms, even the citizens also had this as part of their fundamental right. Fine, that was Article 19 Clause 1F. So Article 31 क्या था? Article 31 में specifically the Constitution had provided that every individual has the right to property and the government cannot, nobody cannot deprive them of the right to property without following the due procedure. Okay, without following the due procedure, the government, majorly the government, cannot deprive anyone of the property which a person is holding. Okay, this was guaranteed under Article 31. So next comes this Constitutional Amendment Act, that is 44th Constitutional Amendment Act 1978. Basically, we know about this 44th Constitutional Amendment Act. Many of the changes were brought. In fact, many of the changes were brought in 42nd Amendment Act, and usko बहुत सारा provision को reverse कर दिया. So many of the people also say this 42nd and 44th Amendment Act itself as a mini constitution. So one of the important provision which was introduced in in 44th Amendment Act is that ये जो दो provision है, दो article है under the part of fundamental right, that is part 3 of the Indian Constitution. This will cease to exist. That means these two will not be there. They will not be part of fundamental right. And ये जो article 31 के अंदर था, that is none of them shall be deprived of the property except through the procedure of law. So that has been transferred to Article 300A. Same चीजें हैं अभी Article 300A के अंदर आ गए. तो पहले 31 के अंदर था, अभी Article 300A के अंदर आ गए. So what is the difference? तो पहले Article 31 के अंदर था, तो if at all there is any violation, okay, so let me just tell you again. That article guaranteed that none of the citizens shall be deprived of the property except by the procedure except without following the procedure established by the law. उसका मतलब है if at all the parliament is passing any law, parliament is passing any legislation, the government has to follow that. Then only it can deprive anyone of the right to hold the property. Fine. So that was guaranteed. Now it is part of Article 300A. उसका मतलब है Article 31 violation हो गया. One could have directly approached the Supreme Court, which is under Article 32. Under Article 32, you know that the citizens have the right to directly approach the Supreme Court if at all there is any violation of fundamental right. So now if at all any person's right of property is violated, if it is acquired without providing the due compensation, one cannot directly go to Supreme Court. One has to approach the different levels. पहले session court में जाएगा, lower court में जाएगा, then high court, then finally Supreme Court through appeal. So current provision is that only Article 300A is valid. Okay, Article 19 Clause 1F is no more. Article 31 is no more part of fundamental right. Right to property is not a fundamental right in India. Since this is part of 300A, right to property is a constitutional right. What is a constitutional right? any right which is guaranteed through the constitutional provision. Fine. So if at all there is any constitutional provision for any particular right, through constitutional article it is guaranteed, it is said to be constitutional right. So what is a statutory right? Statutory right क्या होता है? Any right which is guaranteed by law. Any right which is guaranteed by law of the parliament or the state legislative assembly, that is called a statutory right. How right to property is a statutory right? So we have a right, we have a law for that, है ना? ये जो land acquisition rehabilitation का जो act है, so that guarantees everyone's right. Fine. So based on that law, this is also a statutory right. And the third option, मैंने बोला ये fundamental right तो गलत है. It is a constitutional right based on the article 300A. Statutory right based on the Land Acquisition Act. And how it is a human right, I'll come to that. That is what the Supreme Court has said in the recent case. इस केस के बारे में मैंने बताया था. In Himachal Pradesh, the state government has acquired around 3 hectares of land which was belonging to a woman for the construction of road, and that woman she was not given any kind of compensation till now. So she had approached the court, and court में क्या हुआ? The state government said that this was acquired for the construction of road, and this had been under the possession of the government for more than 12 years, है ना? तो इसलिए we are following this doctrine of adverse possession. So based on the doctrine of adverse possession, we are not going to give any compensation as a state government बोल दिया. So I'll just briefly tell this what exactly doctrine of adverse possession. Okay, in the Indian legal ये जो हमारा कोर्ट्स का प्रोसीजर्स है उसके अंदर देयर इज अ डॉक्ट्रिन, दैट इज डॉक्ट्रिन ऑफ एडवर्स पोजीशन. तो बहुत लोगों को पता नहीं है बेसिकली व्हाट एग्जैक्टली इज दिस डॉक्ट्रिन ऑफ एडवर्स पोजीशन. सपोज इफ एनीवन्स लैंड इज देयर और एनी प्रॉपर्टी इज देयर इन इंडिया एंड दैट हैज बीन ऑक्युपाइड बाय समवन एल्स. Okay, that has been occupied by someone else for more than 12 years. Another person is living in that property, or another person is having possession of that property for more than 12 years. In that case, the land belongs to that possessor. The owner cannot claim the land. Okay, you might be surprised why. Yes, because the owner had not initiated any recourse for 12 years. Only in that case, this doctrine would apply. Okay, suppose if at all the owner had not initiated any recourse against this adverse possession, the land will belong to that person who is holding it. You know, this also has a positive end. So many times maybe some of the poor people or some of the people who are living in one particular land, उसका suddenly और कोई आ गया है कि इतने साल आप रह रहे थे, ये लैंड जो है ये मेरा है, ऐसे बोल के कुछ डॉक्यूमेंट दिखा दिया. सो दे विल हैव टू वेकेट टू अवॉइड ऑल दीज थिंग्स, बिकॉज डॉक्यूमेंट तो फोर्ज कर सकते हैं, डॉक्यूमेंट ऐसे ही बना के लैंड रिकॉर्ड्स का तो हमें पता है इंडिया में कैसे है. तो टू अवॉइड ऑल दीज थिंग्स, टू प्रोवाइड सम काइंड ऑफ जस्टिस टू द पुअर हु हैव बीन लिविंग फॉर अ लॉन्गर टर्म, तो दिस डॉक्ट्रिन ऑफ एडवर्स पोजीशन है. बट दिस हैज बीन रॉन्गली यूज्ड बाय द स्टेट गवर्नमेंट इन दिस केस. It is very clear that that land had belonged to this lady and उनको तो compensation देना चाहिए था. But the state government is saying this belonged to us. This was under the possession of state government for more than 12 years. So this, based on the doctrine of adverse possession, this land belongs to us. Supreme Court said, Supreme Court said, yeah, one nice thing, that we are a welfare state. India is a welfare state. So if at all you are using this doctrine, if at all we are using this doctrine to say that we are having the possession, the state will become an encroacher. Okay, there is a difference between a welfare state and encroacher, and the state cannot act as an encroacher. You know, so since you have encroached this land, you have to give her compensation. Okay, ऐसे बोल के Supreme Court said, please give her a compensation of 1 crore. Okay, so that 80 years old lady is getting a compensation of 1 crore now. And on what power the Supreme Court is saying? It is saying based on the article 142. Supreme Court using this, it is saying that using its power under article 142, it is directing the state government to provide a compensation of 1 crore Fine. So what is this Article 144? Article 144 के अंदर the Supreme Court has the power to enforce its judgment or decree, है ना, to provide for complete justice. So in that case, if any case, in any special case, the Supreme Court is directing anything under the Article 142, that has the validity equivalent to law. That is guaranteed by the Constitution. Using that power, the Supreme Court has given the direction to the state government saying that आपको compensation देना पड़ेगा. So in the further future cases, the Supreme Court also says the right to property is a human right. Okay, right to property is a human right, and the government cannot violate this. Government cannot violate this without following the due process. Matlab, if at all you want to occupy anyone's land, okay, bring a legislation or bring some clear-cut procedure and provide them with a compensation, identify their rights and then provide the compensation, then only you can acquire. Without following all this procedure, you cannot acquire their land. This has been said by the Supreme Court. इसलिए the right to property is also human right. Okay, this is based on Supreme Court's judgment. To quote this, the Supreme Court also brings one of its earlier judgment where it said, that is State of Haryana versus Mukesh Kumar. In this case, this is a case of 2001. In this case, the Supreme Court had earlier also said that right to property is a human right. It is not only a constitutional, not only statutory right, it is also a human right. It is quoting it again, and it has been confirmed by the Supreme Court now that state cannot take possession of this property without following the due process, because the right to property is a human right. I hope that is clear. Any doubts?
Yes, sir. I have one doubt.
Yes.
Sir, can you explain the difference between the terms like procedure established by law and due process of law?
Okay. See, the procedure established by law, due process of law, as given in the Article 21, so that is different. And in this context, the right to property, what the Supreme Court is saying, that is different. Okay, here it is saying simply that government has to follow the procedure. Okay, for acquiring the property, it has to set a clear procedure, and then through that procedure, it has to acquire. है ना, कुछ जगह में ऐसे alternatively use हुआ है. Even in newspaper, it has been used. Sometimes it is said to be due process, sometimes it is said to be procedure established. But in the context of right to property, what the Supreme Court is trying to say that government has to follow the procedure. है ना, they should set a procedure for acquiring the property. They should compensate the persons, then it can acquire. Right to property is not absolute in India. Okay, now the Supreme Court is saying that it is a part of human right. It doesn't mean that the government cannot acquire. Yes, it can acquire, but it has to compensate. That is what is Supreme Court is saying. Coming back to this, the difference between the due process and the procedure established, it is clear from Article 21. So Article 21 के अंदर we have this right to life and personal liberty, which cannot be violated except by the procedure established by law. Okay, this is given in Article 21. Fine. So except by the procedure established by law, उसका मतलब है whatever the procedure given in the law, if the government is following that and violating anyone's right to life, है ना, in that case it is fine. But without following that, you cannot do that. ऐसे पहले दिया था. But after the Menaka Gandhi case, the Supreme Court also says that this is not just the procedure established by law, this is also due process of law. इसका मतलब है, even if the government is followed the procedure given as per the law, still the court can go beyond the intention of the law and check whether the law is correct or not. Procedure तो ठीक हो सकता है. Procedure to whatever the procedure the government has followed, that might be right, but the procedure itself is right or not, the procedure set by the government or the parliament, that itself is right or not, ये भी check कर सकता है. That is called as due process of law. This is a concept prevalent in USA that is not there in Article 21, but that is brought to India through Supreme Court in the Menaka Gandhi case. I hope that is clear.
Yes, sir. Thank you.
Thank you. Yeah. Next topic, sedition. So was the speed fine now?
Yes, sir.
Yeah. The topic is sedition. इसमें currently why this sedition was in news, you can see because of the recent arrests in Bangalore and Kashmir. So recently, when the people were protesting against this Citizenship Amendment Act, many of the people were also arrested using the Sedition Act. So ये जो बोला था, it is going against the government ऐसा बोल के the government had arrested few of the people. So in this context, we're just going to see briefly what exactly is this sedition. ऐसे कुछ the government का Supreme Court का judgment अभी तक ऐसे specifically ऐसे कुछ आया नहीं है. Okay, it is not nothing. The topic is not completely current affairs, but since this is in news, we are just going to see the background. Okay, we don't have to go in detail about this. Okay, what exactly is sedition? Sedition का मतलब है like anyone preaching enmity. Okay, enmity or hatredness towards the government, towards the state. Okay, on whom, if at all somebody is talking against the government and trying to incite the people against the government, उसको हम arrest कर सकते हैं. Okay, that act is called as sedition. Okay, talking against the government, bringing hatredness towards the government. So ये पहले कब हुआ था? The first attempt was made by Lord Macaulay. Okay, so basically it was made by Lord Macaulay. He brought this concept in 1837, but finally it was added in 1870. Okay, 1870 तक नहीं था. The sedition of under IPC was not there, but 1870 में it was added to IPC, but first proposed by Macaulay in 1837, right, I remember. And this act was used by the British government to suppress most of the national movement, to suppress the popular movement. If somebody is talking against the government, the British government was saying that you are talking against the government, ये गलत है, तो उसको arrest करो. It has been used to a very great extent to suppress the national movement, to suppress the opinion, and to put a complete control on the people of India. And to basically control the people of India, they had used this. We had very famous examples. So Gandhiji was also arrested, and even Tilak was also arrested on the charges of sedition only. They were given, I think, 6 to 7 years of imprisonment based on the sedition charges, because they were talking against the British government, and Tilak had spoken against the British government's efforts during the plague period 1870s, 1897 में ऐसे हुआ था. So cross 5 months. And based on these charges, they were also arrested. So since this is such a draconian measure, why did we keep it after the independence? After the independence, तो हमारे पास option था इसको हटाने के लिए, है ना? But we did not remove it. We continued this. Why? Because this was also necessary even to bring India together at that point of time. So there were very diverse, divisive forces which might have led to the disintegration of India if there is no suppression of such kind of divisive forces. Because we had just come out of the partition, ये बहुत जरूरी था unity and integrity को maintain करने के लिए. But the issue is that ये जो sedition provision था वो और थोड़ा सा clearly define करना चाहिए था, but that was not done. Okay, जो भी earlier provision है उसी को ही हमने continue कर दिया. Okay, the act of sedition has been continued even after the independence. That is the main criticism. Criticism ये नहीं है कि हमारे पास sedition act है. Okay, sedition act, whatever the sedition provision are there, that is very vaguely defined. Okay, the government can put anyone under arrest saying you are trying to spread the hatredness, you are trying to bring the hatredness or enmity towards the government of India. ऐसा बोल के लगा सकते हैं. Okay, let me just come to this. If any person is arrested based on the charges of sedition, we have our very famous case, Kanya Kumar case. Okay, जो JNU president था, I think 2015-16 में he was president, and that time there were some issues and he was arrested using the sedition provision. अभी तक till recently the case is going on. Right? So suppose if any person is undergoing trial under the sedition case, okay, the charges are non-bailable. Right? Non-bailable का मतलब क्या है? He is too free. He is doing campaigning. Even he was till now he was doing campaigning. कैसे? Non-bailable का मतलब है he is not supposed to get the bail at the police station. The bail can be guaranteed can be given by the court. Court के अंदर दे सकते हैं, but not the police station. That means it is not a easily bailable offense. And second thing, whoever is facing these charges of sedition, he cannot apply for government job. Okay, government job apply nahi kar sakte, and he cannot leave India also. He has to live without passport. Fine. So he would be completely under the scanner of the government. Anyone who is facing the charges. Suppose in that case, the person is found to be guilty. The imprisonment term can go up to life imprisonment. Okay, so this is the maximum punishment which is under this sedition provision. So that is why this is one of the most criticized provisions of IPC. Section 124A, even after being a democratic country where we have given a very wide range of fundamental rights to our citizens, so still we have the provision of sedition. That is why it has been one of the very widely criticized section of IPC. Now, are there any restrictions at all? ये तो completely ऐसे है क्या? No. The government in many of the Supreme Court in many of the cases has clarified. Okay, you can see Ramesh Thapar case, Kedarnath Singh case, Kanhaiya Kumar case के अंदर the Supreme Court has said that the act of sedition, ये जो sedition case लगा रहे हो आप, so that should follow certain criteria, that there should be a disruption of public order, and there should be an attempt to violently overthrow the lawful government, and there should also be threatening the security of the state or public. Okay, so in that case only आपको लगाना चाहिए, ऐसे Supreme Court ने guideline दी है, but there is no specific law as such. Since this is a judgment given by the Supreme Court, it is not completely being implemented. हाँ, this is wherever there is a unnecessary sedition cases लगा रहे हैं, because ये तो prove करना बहुत मुश्किल है. कि गवर्नमेंट बोलते हैं ये तो it is amounting to the disruption of public order, and the people who are saying that no, this is the small issue था, इसको बड़ा बना दिया, so it is pending in front of the court. कन्हैया कुमार केस तो अभी तक चल रहा है. So it is basically, it's a very vague and very wider interpretation, that is the issue. उसके ऊपर थोड़ा सा reforms चाहिए. In fact, many of the committees, even the law commission has recommended उसको निकालो, sedition provision को निकालो and एक छोटा सा provision बना दो, तो और clear कर दो, ऐसे कुछ recommendations है. But अभी तक the government has not taken any step in this regard. Any doubts here?
No, sir.
Okay, thank you. Yeah. The next topic is minority education institution. Minority education institution. So basically, there was a recent some judgment related to the minority education institution. The Supreme Court in January 2020 had clarified certain things related to minority education institution. उनका जो fundamental rights है, तो उसको कैसे infringement क्या हो सकते हैं, infringement क्या नहीं हो सकते उसके बारे में. So let's just talk about this briefly. I'll just give you a brief idea about this. The whole picture, so that it gives some clarity. So before we go into that, let's just see what are the constitutional provisions related to the minority community in India. Okay, we have two articles. One is Article 29, another one is Article 30. What is Article 29? Article 29 says that any section of people has the right to conserve their language, their script or culture in India. Okay, that is, it is any section can conserve their rights, any section can conserve their script or culture. They have the fundamental right to do so. So यहाँ पर minority क्यों है? It clearly says any section. This is what basically it can apply both to majority या minority community. So Article 29 talks that any section has the right to do so. So it is not only the minority, even a majority section can also do so. That means any of the majority section can also say, this is my fundamental right to conserve this religion, conserve this language, conserve this culture. ये हमारा fundamental right है, ऐसे बोल सकते हैं. That is Article 29. Article 30 क्या है? the linguistic or religious minority has the right to establish and administer educational institutions. Okay, so that means if at all there are any minority, that to which kind of minority? Linguistic and religious minority, they have the right, which kind of right? Fundamental right. They have the fundamental right to establish their own education institution and manage its affairs. That is guaranteed under Article 30. Fine. So here comes the Constitution के अंदर दिया है, it says that which two kinds of minority? It is religious and linguistic minority. तो अभी आते हैं, what exactly is this minority? Who is a minority? Which proportion of the population should be there to consider them to be minority? Is it 50%? Is it 10%? Or it is 5%? Okay, if we talk about who is minority, it is not defined in the Constitution. The Constitution does not say that who is a minority, what proportion amounts to minority. But we have an act, National Commission for Minority Education Institution Act. Through this act, where it is defined who is a minority. The minority is any community which is notified so by the central government. Okay, minority is any community which is notified as a minority community by the central government will become minority. So as per this act, they would be minority and they have the right to establish and administer their own institutes. So based on this act's the provision, the central government has notified 6 religious minority communities. Okay, there are 6 religious minority communities officially notified by the central government. What are the 6 religious minority communities? It is not that difficult to remember. Okay, try to remember this code word. Okay, it is MSCBJP. Okay, Muslim, Sikh, Christian, Buddhist, Jain, and Parsi. These are the 6 minority communities, religious minority communities notified by the central government under the National Commission for Minority Educations Act. Okay, पहले हमने पता चल गया what are the constitutional provisions. We have Article 29, Article 30. दूसरा है कि we got to know who are the minority. There is no definition as such. Whoever the government is saying ये लोग minority है, they will become minority. Okay, that is as per the National Commission for Minority Education Act. Okay, तीसरा है, what exactly is this minority education institution? यहाँ पर भी बात हुआ था minority education institution and उसके लिए एक act भी बना हुआ है. What exactly is minority education institution? Okay, any education institution established and administered by minority community. Fine. So any education institution established and administered by the minority community, that is the people who are establishing this, they should be in majority. The minority community should majorly hold this institution. Then only this institution will become a minority education institution. Suppose established kar diya, so what are the benefits for them? So they will not come under the reservation of Article 15. कल हमने discuss किया था in detail about this Article 15. They will not come under so, and there is also reservation provision under Article 21A, that is right to education. Even this provision will not hold true for them, and there is also they can provide minority के लिए reservation up to 50%. Okay, generally total reservation itself would be up to 50% in other education institutions, but यहाँ पर they can provide minorities के लिए reservation up to 50%. Fine, and they can also have a separate fee structure. So any minority education institution established by a minority community can have this benefits. Okay, that it should be specially established for the benefit of minority. बहुत सारा minority education institutions है, तो to control them, that is to regulate these minority education institutions, we have a National Commission for Minority Education Institution, NCMEI. Okay, this has been established by the government to regulate these minority education institutions. So let's just briefly say this National Commission for Minority Education Institution. So government ने एक act लाया था. Based on this act, it is saying that so all these minority education institutions will be regulated. What exactly is this National Commission for Minority Education Institution? It is a quasi-judicial body. That means it has both administrative as well as judicial power. It regulates the certification of minority education institution, मतलब it decides कौन सा institutions are minority education institutions and कौन सा institutes नहीं हो सकता है. And इसका composition क्या होगा? The chairman would be a judge of high court along with the 3 members to be nominated by the central government. This is the composition, and this has the powers of civil court, and this will also has the power of recommendatory power. That means it can recommend certain things to the central government, and also it decides upon the disputes regarding the affiliation, and it also has the power to inquire suo motu. Uska matlab hai it can inquire any if there are any issues by itself. It is not required to wait for some kind of complaint. Okay, suo motu bhi kar sakte hai, and it can also cancel the minority status. It can cancel the minority status to the minority which was already guaranteed. It was already granted to the minority education institution. If it is found so, if there are any violations, then it can cancel so. तो हमने तो देख लिया what are the powers and composition. Now National Commission for Minority Education Institution है ना, तो यहाँ पर तो this is not given that this is for which kind of minority. So this should be for which kind of minority. Article 30 के अंदर दिया है this. It is any kind of such thing would be based on religious minority or religious minority or linguistic minority. But ये जो कॉन्स्टिट्यूशन के अंदर ये जो एक्ट के अंदर जो है प्रोविजन बेस्ड ऑन दैट इट सेज व्हाट एवर द सेंट्रल गवर्नमेंट नोटिफाइज एज माइनॉरिटी ओनली दोज माइनॉरिटी एजुकेशन इंस्टीट्यूशंस वुड कम अंडर नेशनल कमीशन फॉर माइनॉरिटी एजुकेशन इंस्टीट्यूशन. सो बेसिकली एनसी नेशनल कमीशन फॉर माइनॉरिटी एजुकेशन इंस्टीट्यूशन जो है इट टॉक्स अबाउट द माइनॉरिटी एजुकेशन इंस्टीट्यूशंस फॉर ओनली 6 ग्रुप्स, दैट इज मुस्लिम, Sikh, Christian, Buddhist, Jain and Parsi. If at all there are any education institutions established by these communities, then only it comes under National Commission for Minority Education Institution, because the government has notified only religious minorities till now. It has not notified any kind of linguistic minorities. Okay, then what about linguistic minority then? So linguistic minority के लिए there is separate provision, National Commissioner for Linguistic Minority, as guaranteed by the Article 350 Clause B. Okay, Article 350 Clause B says that there shall be a special officer for linguistic minorities in India. Okay, so इसलिए they have established a separate body for linguistic minority, but this body is not as powerful as NCMEI. Okay, it is just a recommendatory body. Let's come to the last part. So what exactly is this Supreme Court ने बोला? जो अभी Supreme Court, whatever the Supreme Court has said, so that is related to one of the acts which was there in the West Bengal. It is West Bengal Madrasa Service Commission Act. West Bengal Madrasa Service Commission Act. This is an act which provided that this commission has the right to appoint teachers for madrasas in West Bengal. The government of West Bengal wanted to control the quality of education which is imparted in madrasas, इसलिए एक commission बना के, so it said that आपको इस commission के through you have to appoint teachers to madrasas. So some of the people had gone to the court saying that this is violation of Article 30, where it says that a minority community has the right to establish and administer their own institution. ये तो 30 का violation हो गया. Now what exactly the Supreme Court has said? The Supreme Court brought one of these cases. It is very famous case, TMA Pai versus State of Karnataka 2002 case. In that case, it had said that Article 30 is not absolute. Okay, the 30 के अंदर जो right दिया है, that is right to establish and administer one's education institution, one's own education institution. This is not completely absolute, है ना? जो भी rights है, you might have your own special fee structure, special reservation, सब कुछ हो सकता है, but we cannot say you have the complete freedom. The government can interfere to ensure the quality of education. To ensure the quality of education, हम interfere कर सकते हैं. So this has been said by the Supreme Court in this case. Now again, the Supreme Court is saying, Supreme Court said in January 2019 also that whatever we said, I'm bringing it again. So government can bring some kind of regulation even in minority educations to ensure excellence. To ensure excellence, we can bring some kind of regulation, so that will not amount to the violation of right to have administer one's own education institution under Article 30. Is that clear? Any doubts?
Hello, sir.
Yes.
Good morning, sir. Sir, just difference in Article 29 and 30. Sir, just for clarity, Article 29 is for all, but means whether it is majority or minority, na?
Yes. Article 29 is for all, because Article 29 के अंदर it is not said to be a minority. It is saying that any section of people have the right to conserve their language, culture or script. So even the majority community also have this right, but Article 30 is only for minority community.
Okay, sir. Thank you.
Any other doubts?
No, sir.
Shall we take a short break?
Yes, sir. We'll take a short break of 5 minutes.
We'll take a short break of 5 minutes, then we'll continue.
Okay, sir.
Yeah. I hope this is clear, the previous ones. Now, the next topic is Shabarimala temple case. Shabarimala temple case, I hope all of you know about this Shabarimala. Where exactly is this Shabarimala located? It's in the state of Kerala. It is one of the very old temples which is located in almost the interior location of Western Ghats. There is also a river flowing next to this this temple, very near to this temple. It is located on the hills of Western Ghats. So that river is Pamba River. Pamba River. Try to locate this Shabarimala as well as Pamba River. The atlas, तो आपका geography location भी cover हो जाएगा. So what exactly is this Shabarimala case? So Shabarimala temple had a provision that the woman in the reproductive age would not be allowed to enter the temple. ऐसे बहुत पुराने टाइम से एक ट्रेडिशन फॉलो कर रहे थे. So it's only the men or the women beyond this reproductive age, or the very young kids or the old age women were allowed to enter. And this practice was questioned in the Supreme Court, and finally Supreme Court, after a long prolonged battle, the Supreme Court finally it gave the verdict by 4:1 ratio. The Supreme Court judges, the 5 bench judges of Supreme Court, through 4:1 ruling said that the woman should be allowed to enter. It allowed the entry of women into Shabarimala temple, saying that if at all the state is denying this, this would become the violation of Article 17 of Constitution. What is Article 17 of the Constitution? It says that there shall not be any kind of practice of untouchability. If at all you are not giving entry to women, it is a kind of practice of untouchability. So that should amount to practice of untouchability. इसलिए आपको allow करना चाहिए. वैसे बोल के the Supreme Court had given the ruling. So while giving the ruling, Supreme Court said one of the things that it is relying on the constitutional morality to come to this conclusion that this should not be there. This ये जो practice है ये होना नहीं चाहिए, because we are coming to conclusion based on the constitutional morality. So what exactly is this constitutional morality? So if you see this Article 25, the grounds of restriction which can be imposed for the right under Article 25, in one of the ground is morality. Morality दिया है. So in that sense, the Supreme Court is saying there is a concept called constitutional morality. The constitutional morality का मतलब है ये जो basic principle है which the constitution makers which wanted to follow, the morality of these minds, the morality which is there in the entire constitution, उसको हमें follow करना चाहिए. That morality says that this practice is violation of Article 17, तो इसलिए हमें अलोक करना चाहिए. ऐसे बोल के constitution morality के बारे में बात हुआ था, but remember it is not completely defined anywhere. Okay, तो एक चीज है ये हो गया constitution morality. दूसरा चीज है कि there is this doctrine of essentiality. Doctrine of essentiality. So this was defined by the Supreme Court in one of the very early cases, that is Shiror Mutt case in 1954, saying that there are certain essential practices, okay, essential practices which are inherent, which are integral to any kind of religion. है ना? So only these practices we should not suppress. These essential practices should not be suppressed under, which are guaranteed under the freedom of religion. Okay, but non-essential practices can be suppressed. The government can suppress the non-essential practices. So ऐसे बोल के classification बनाया था. Those essential practices should not be suppressed at all. ऐसे बोल के. And who would decide that? And who would decide that? It would be the responsibility of the court to decide which are essential practices, which are non-essential practices. This has been there in many of the cases. Now, finally the center has approached the Supreme Court saying that ये जो constitution morality बोल के आपने verdict दिया है, allowing the entry of women, so this case along with this case should be examined in detail by the Supreme Court. So please refer this to 7 judges bench. Okay, 7 judges bench को आप refer कर लीजिए. So then we need a detailed examination of this, and also the central government has said, so why only Hindu practices? There are also such discrimination practices in all the religions. सबको देखना चाहिए ऐसे बोल के the government has submitted. The court has accepted that it wants to look. Okay, so basically now the 7 judges bench will look into this practice of allowing entry or not allowing entry into Sabarimala case, or even the practice of doctrine of essentiality, or even allowing the entry of women into any other religious institutions. That would be now decided by the 7 judges bench. Okay, that is still pending. Any doubt here?
Sir, do these benches of higher number of judges, when they're sitting in the bench, can they overturn the decisions taken by the lower number of judges?
Yes, they can overturn. In fact, the same judges bench can also say, if at all this was taken up by another 5 judges bench, so it could have overturned. Any judgment of the Supreme Court can be overturned by any other judgment, subsequent judgment.
Okay, thank you.
The practice is that usually the higher judges bench only overturns. Okay, that is what the practice is.
Okay, sir.
So now the next topic is impeachment of US President. And why it is in news? Because in December 2019, we started to hear that there has been impeachment proceedings going on against the Donald Trump, which is the current president of US. So उनके ऊपर impeachment proceedings start कर दिया था. We saw that impeachment proceedings successfully clear भी हो गया. Newspaper में आ गया that Trump stands impeached, and that was referred to another house. But finally हमें ये पता चला कि he was not removed. So there's so much of confusion. Trump was impeached, but he was not removed from the house. What exactly is the meaning of this? What does this mean that even after being impeached, he is not removed? Okay, there's some confusion about this. Let's just clarify this. So what exactly the procedure of removal of US president? So let's just go through that. We also have some certain procedure for removing the president of India also. Let's just, for our easy understanding, I have prepared this this graphical representation. There are 4 stages in the removal of president. Okay, both in India as well as USA. This is the first one, this is the second one, this is the third one, this is the fourth one. Okay, the 4 stages are there. In the first stage, we will consider, the first stage would consider what are the grounds of removal of president. On what grounds a president of a country can be removed. In India, it is given in the constitution that the violation of constitution is the only ground for removal of president in India. Okay, और कुछ grounds दिया नहीं, only in case of violation of constitution he can be removed. What about USA? USA में there are 3 grounds which are mentioned. One is treason, another one is bribery, third one other high crimes and misdemeanors. Okay, so these are the 3 grounds which are given in the USA's constitution. Based on these grounds, he can be removed. Okay, ground to ho gaya. Ground, suppose if at all any member is saying that हाँ ऐसे ground आ गया है, we have to remove. What is the procedure? Next is initiation. How it is initiated? In India, it can be initiated by either house of the parliament, but in USA, it should be only in the lower house, that is House of Representatives. यहाँ जैसे हमारा लोकसभा, राज्यसभा है, वहाँ पर भी है House of Representatives, then Senate, है ना? Senate is upper house, House of Representatives is the lower house. In India, this resolution can be introduced in either of the house. Lok Sabha में भी, Rajya Sabha में भी introduce कर सकते हैं, but in USA, this will be introduced only in the House of Representatives. Fine, this is the second stage. Initiation हो गया. Then how the voting would happen? Once it is initiated, India में एक और चीजें है. Initiation के time में this should be signed by 1/4 of the members of that house. Then only this resolution will be accepted. In USA, there is no such mechanism. Okay, there is no need of such thing. And what kind of majority is required? In India, it is the 2/3 of total majority. Okay, total majority का मतलब है including all the vacancies, absentees, सब मिला के total majority. In that 2/3 members should agree for the impeachment, तब भी remove होगा. In the first house, if it is introduced with a total of 1/4 of the members and also 2/3 of the total majority, then it will be passed to the second house. But in USA, in the first house, it is passed through simple majority. Okay, it will be passed through simple majority in the first house, that is the House of Representatives. Then it will be passed to the Senate. India में क्या होगा? कोई भी एक house में introduce होके दूसरी house में होगा. In that second house will act as an inquiry house. It will act as a court and it will look into the matter. Even the president will be given a chance to justify what exactly are his actions and what led to this charges and all. So then after that, the house will vote. Even in the second instance also, it is the 2/3 of total membership. If at all the second house also passes the resolution with 2/3 of the total majority, at that moment itself, the president stands impeached. But in case of USA, there also the Senate acts as an inquiry house. If the Senate finds it guilty of जो भी charges के ऊपर frame किया है, then it will be voting in that 2/3 majority would be required. If the Senate passes through this, Senate passes this resolution, then in that case, president will be completely removed. This is the procedure. Let me highlight the difference again. यहाँ पर difference है, एक ground का है, एक ground का है. Here it is only for the violation of the constitution. Here it is for 3 charges. Okay, this is the first difference. And second difference, you can see this can be initiated in India in either house of the parliament. Here only in case of House of Representatives. The third one, in case of introduction, there is a requirement of 1/4 of the member. There is no such provision. And in case of the first house, it is 2/3 of the total majority. There it is simple majority. Okay, this is third difference and this is fourth difference. And the fifth difference would be the same. Okay, second house में same ही है. Whichever the house be introduced, that will be passed to the second house, that will act as a court, and then it will be passed through 2/3 of the majority. USA also, it is 2/3 of the majority in the second house. Now come to the Trump's case. Trump case में क्या होता? The grounds which are the grounds on which he was charged, he was said to be removed. That is based on his actual interference. He was charged with interference in the 2020 presidential election. Okay, basically ये जो अभी 2020 में presidential election होने वाला है, he said to have taken the help of Ukraine, to malign the name of the opponent and also to give the wrong directions to the Congress. So ये सब charges के ऊपर he was framed, and he said it is said that he even obstructed the inquiry process when the resolution was pending in House of Representatives. ना तो इसलिए based on these 2 counts, the resolution was passed in the House of Representatives. Okay, वहाँ पर तो they had the Democrats had the majority, तो इसलिए pass हो गया with a simple majority. But when it came to the Senate, okay, there the Republicans had the majority, they did not pass this. Okay, since it was passed in the House of Representatives, he is said to be impeached. But since it is not passed in the Senate, he is not removed from the House. So he is not removed from the presidency. If at all he is passed in the Senate, if at all this is passed in the Senate also, then only in that case he is said to be removed from the office. Okay, he is impeached. That is, impeachment refers to only in House of Representatives. Removal is final reference to the Senate. Okay, and till now, none of the US presidents have been removed, but he is the third US president to face the impeachment. He has been impeached. Okay, इसके previous भी था हमारा Bill Clinton. He was impeached by the House of Representatives, but he was not removed by the Senate. Is that clear?
Yes, sir.
Any doubts?
Sir, कुछ queries हैं, sir? Yes, sir.
Yeah, please. बताइए.
So this comparison and this particular news, is it very important to be remembered word by word from the student's perspective?
Okay. So it is not required to be remembered the exact news as such, but it will be good if they can remember the comparison between the procedure in India and as well as USA.
Okay, sir.
Okay, तो because ये जो comparison between the different constitution के ऊपर mains में question आए हैं, already mains का syllabus में भी है, and this was in news currently, so this would be important. The procedure between the both USA and India, this is important.
But in particular to the president as well.
Yes, particularly to the president.
Okay, thank you.
Hello, sir. Yes, sir. So, in case of India, if the president does not follow the advice of Council of Ministers, will it be considered as a violation of Constitution?
Okay, if the president does not follow the advice of Council of Ministers, yes, it can be said to be. It is said to be a violation of Constitution because he is bound to follow the advice of Council of Ministers. He cannot say that he will not follow. ऐसे तो situation हुआ नहीं है. जो भी advice दिया है, either it is kept on hold or it has been returned back. तो ऐसे कुछ provision है ही नहीं है इंडिया में. He has to give his, he has to consider their advice.
Okay, sir. Thank you.
Anything else?
No, sir.
Yeah, thank you. The next one, pardoning power of president. The pardoning power of president refers to the recent Nirbhaya case. We all know about Nirbhaya case. One of the very horrific cases which we had seen. It took for so long time for the convicts to be hanged, and they were recently hanged. And in this context, their mercy petition was pending in front of the president. So finally, वो जो हुआ था, so in this context, we are just going to see this what exactly are the pardoning power. Okay, before that, even this is also was in news. So इसलिए I'm just trying to bring your attention to this part. So basically, any person who is facing a death sentence will have to go through different procedure, different stages of protection is available to that person. Okay, so why this hanging of Nirbhaya convicts took so long? People were complaining, people were criticizing, but there is a clearly set procedure which our judiciary follows to, and because of also certain loopholes which are present over there in these steps. तो ये इतना डिले हो गया था. Okay, let me just tell you what are the different steps through which any death sentence convict would have to go through. Okay, first stage is any kind of जो भी subordinate court है, district session courts हो सकते हैं, special court हो सकते हैं, fast track court हो सकते हैं. That is the first court which would give it verdict. In this case, there was a special court which gave the verdict, that is all of them should be hanged. Okay, they would be given death sentence. Once this death sentence as a final word given by that first court, that would be taken to the High Court. Okay, next High Court. Any kind of death sentence which is given in the session courts, that has to be confirmed by the High Court. And this, once the High Court confirms this, okay, once the High Court upholds the death sentence, the petitioner has the option of going to Supreme Court. Okay, Supreme Court as an appeal mechanism, he can go to the Supreme Court, and once the Supreme Court also says, हाँ ये डेथ सेंटेंस ठीक है, ये सही पनिशमेंट दिया है, ऐसे बोल के कंफर्म हो गया, उसके बाद में क्या है, देयर आर 3 more provisions available. Okay, once the Supreme Court says this is a final verdict, है ना, this is a final judgment, हाँ ये ठीक है, the convict has option of filing a review petition. Okay, so what exactly is a review petition? So review petition is based on the Article 137. Article 137 of the Indian Constitution. Article 137 of the Indian Constitution provides, it has the provision which provides the Supreme Court with the power to review any of its own judgments or any of the judgments of subordinate court. This is just some kind of special power given to the Supreme Court, saying that आपके पास ये power है ना, कोई भी ऐसे लगेगा आपको कोई भी justice has not been done properly, or if you want to review your own judgment आगे जाके, you can use this mechanism ऐसे बोल के. So once the Supreme Court has confirmed that this death sentence is fine, the convict have the option of filing a review petition using Article 137 provision. But the condition is that it has to be filed within 30 days. Within 30 days of the final verdict given by the Supreme Court. Once this review petition is taken up, once the Supreme Court says that even in the review petition also, ये death sentence सही है, then after that the convict will have the option of filing a curative petition. So what exactly is this curative petition? Curative petition is also derived from the provision of Article 137 as well as Article 145. Article 145 of the Indian Constitution gives power to Supreme Court to frame its own rules for its functioning. So based on these power, the Supreme Court has designed this some kind of special petition, that is curative petition. Remember, curative petition is not part of the original Indian Constitution. Okay, ऐसे कुछ provision नहीं है, but based on the Supreme Court judgment, that is based on the Supreme Court judgment of 2002. Okay, in 2002 there was a case. So in that case ज़्यादा important नहीं है, but after that case Supreme Court brought this concept of curative petition, based on which, suppose if at all there is any violation of the principles of natural justice, and if the convict can establish this, then the Supreme Court can take up this case again and ask for fresh examination of the case. That is what is curative petition. Okay, this would come after the review petition. Review petition bhi ho gaya, then there would be curative petition option. Curative petition is something like a final. Okay, final option hoga, and this, remember, this is not a matter of right of the petitioner. This would be the like some kind of at the discretion of the court. Okay, and also remember, this would not be done in an open court. This would be done in a judge's chamber unless and until specifically asked for this. That is what is curative petition. निर्भया केस में क्या हुआ? स्पेशल कोर्ट ने बोल दिया डेथ सेंटेंस यस करेक्ट, दिल्ली हाई कोर्ट भी बोल दिया डेथ सेंटेंस करेक्ट, सुप्रीम कोर्ट भी बोल दिया. That was also filed in review petition. Review petition में भी Supreme Court confirmed this. Then they filed for curative petition. The Supreme Court did not accept the curative petition. It said that it is not eligible, and then finally they had the option of going to mercy petition. Okay, mercy petition क्या होता है? It is not in front of the president. It is in front of the, sorry, it is not in front of the Supreme Court. It is in front of the president. Okay, the last final option would be mercy petition. So mercy petition is something which we say the provision of executive clemency. That means these are the judicial powers given to the executive. Okay, executive, हमारा executives कौन होते हैं? It is council of minister, but exercised by the president. Okay, this power would be exercised by the president, but based on the advice of council of minister. Okay, there are certain powers the president can use. Okay, in the case of judiciary, suppose in any of the cases it is it is observed that there is some kind of mistake has happened from the judiciary, which rarely happens, or if they feel that the kind of punishment which is given is too harsh, in that case the president has the option of pardoning, okay, changing that kind of punishment into some different forms. That is what is pardoning power of president. Okay, pardoning power of president, that is given under Article 72. Fine. So there are 5 types of pardoning. There are 5 types of powers which are used by the president, can be used by the president to pardon or bring some kind of changes in the sentence. Okay, let's just briefly go through this. Let's just see what exactly are these 5 types. Fine, I have arranged this in this order based on the type of change. Okay, remember the first one, reprieve. Reprieve का मतलब है reprieve is only temporary. Reprieve is only temporarily some kind of relief is given. Suppose there is a death sentence is happening, okay, and the president wants to take more time so that this more time would be given for this person. And also remember, ये जो मैंने पहले बताया था, ये last curative petition, mercy petition is not necessary has to be filed after the curative petition. It can be filed even after the review petition. This happened in Nirbhaya case also. After review petition, they filed the mercy petition, then they went to finally curative petition. Suppose if the convict has not exhausted all the measures and there is a death sentence issued, government order कर दिया, आप अभी execute कर दो, they can approach the president saying that हमें थोड़ा सा temporary relief दे दो. In that case, the president can give reprieve. This is only for temporarily. Remember, it is only for temporarily. Okay. उसके बाद में थोड़ा सा और ज़्यादा relaxation. That is commutation. Commutation में क्या होगा? So whatever the sentence is given, that sentence would be the term of the sentence would be same, but the form would be different. है ना? The term of the sentence is same, but they would change the form of sentence. Maybe some rigorous imprisonment था, उसको अभी change कर दिया simple imprisonment. But if at all it is given for 15 years, he has to serve the 15 years. Okay, there is no change in the term. That is what is commutation. The remission क्या होगा? There would be change in the term, but not change in the form. Okay, rigorous imprisonment for 15 years, so that would be reduced to rigorous imprisonment for 10 years. Okay, that is what is remission. He is remitted, but the form is same. Okay, दोनों का difference आप समझ लो. Respite. What is respite? In case of some special condition, the government, the president has the power. The president has the power to say some kind of temporary relief. It can be both in terms of the term as well as in terms of the form. Okay, some kind of special measure. Maybe in case of ladies, the lady has become pregnant or उनका children हो गया और जो भी special condition है. Okay, so that is what is respite. The last one is pardon. Pardon का मतलब है it is completely removing the punishment. है ना? जो भी उसके ऊपर charges था, जो भी punishment था, पूरा pardon कर दिया, पूरा हटा दिया. That person will become completely normal. There are no charges, no disqualification, nothing. That is what is pardon. This is something of the highest order. Okay, this is of the lowest order. Reprieve is only temporary. Commutation is the change in the term. Remission is change in the form. And respite is some kind of special consideration. Pardon is completely removing the any kind of completely absolving the crime which is done. Okay, दोनों disqualification की हटा दिया, term भी हटा दिया and form भी हटा दिया. So now, what is the difference between the? Let me just clear this. What is the difference between the power of president and the governor? In case of governor is also having some kind of pardoning power. What is the difference between the pardoning power of the president as well as the governor? In case of president, the president's power extends up to the executive power of the union. Okay, जो भी union list के अंदर जो भी laws है, उसके अंदर if at all there is any violation, and if any of the person has been punished for such kind of violation, the president has the power to pardon. That goes for the governor in case of state law. State executive power कहाँ पर भी रहेगा? In those cases, the governor has the power. This is the first difference. Second difference, the president can pardon the death sentence. Pardon means completely absolve. है ना? The president can pardon the death sentence, but the governor cannot pardon the death sentence. The Third difference is president can also pardon in case of court martial. ये जो armed forces के अंदर court martial होते हैं, that can be pardoned by the president, but the governor cannot do the pardoning of court martial. Fine. And obviously it is, I have already said that this pardoning power is exercised. This pardoning power is exercised on the advice of Council of Ministers. Okay, there are certain conditions. There are certain conditions in regarding the implementation of this pardoning power. What are the conditions? Supreme Court has also said. The first condition is that there is no right of hearing of this convicts. So, जो भी pardoning mercy petition लगा के आ रहे, you cannot say my petition should be heard. Okay, this is just considered as a mercy. It is not a right of any person. Second one, the president is not required to give any reason for rejecting. Okay, if the president is rejecting any kind of the mercy petition, is not required to give any reason for that. And the third one, whether it is subjected to judicial review or not. Yes, it is subject to judicial review. This has been confirmed by the Supreme Court, saying that if any such kind of mercy petition is considered in the intention of arbitrary or malafide, okay, in that case this can be questioned in the court of law. मतलब कोई भी, क्योंकि president का मतलब तो council of minister है. Council of ministers is our council of minister who are elected representative. If at all they are pardoning someone, their close relative है, for their own benefit हमने कर रहे हैं without considering the actual grounds, then this can be questioned in the court of law. Okay, that is where the judicial review will come into the picture. And the last issue, the recent issue भी था. Okay, suppose if at all there is any delay in considering the mercy petition. Okay, in that case, the Supreme Court can consider this as a special case and can convert the death sentence into lifetime. This happened in the case of Veerappan ka jo aides the. So Veerappan ka jo supporters the, they were actually given death sentence and their mercy petition was pending in the Supreme Court. It was pending before the president, and that was pending for a very long time. And in that case, the Supreme Court in 2014 said that since they have been waiting for the mercy petition for a very long period of time, this is a violation of human right. Why to make them wait? Okay, they are waiting in a state of mind that unka death sentence hoga ya nahi hoga. This is inhuman. Okay, so in this case, the Supreme Court has the power to to commute their sentence from death sentence into lifetime, and that has been done in this case. ये जो वीरप्पन का supporters थे, they have been transferred from death sentence to life. Any doubts here?
Yes, a few doubts, sir. So there is one question: does pardoning make them non-convict, or they are still convicts? And after being pardoned, can they contest polls as well?
When I said this pardon, ये जो last power है, pardon, मतलब even though we are saying this as a pardoning power of the president, when we are saying pardoning power, generally we are referring to all the different types. उसके अंदर there is a specific type of pardon. Pardon का मतलब है completely absolved, है ना? Their complete crimes is completely removed. जो भी restriction था सारा remove हो गया. They can contest the election. Everything is absolved completely. That is what is pardon.
Thank you, sir. Sir, there is one small doubt, sir. Is there any kind of difference between the appeal from the High Court to the Supreme Court and the special leave petition that a person files in the Supreme Court?
Come again?
Sir, is there any kind of difference in the nature of the appeal that a person makes in the Supreme Court against the judgment of the High Court and the special leave petition?
Yeah, the appeal ka jo mechanism hai, that is coming under the appellate jurisdiction. That is a normal procedure, and special leave petition is again a special mechanism that is only should be used in a rare case where the appellant can use it, saying that यहाँ पर ठीक से judgment हुआ नहीं है, and the Supreme Court shall consider ऐसे बोल के कुछ एक petition डालता है, so that can be considered or not. Okay, usually SLP is used in the cases where there is an issue between the center and state. Usually, commonly SLP is used in the river water disputes.
Okay, sir. Thank you, sir.
Ninth schedule. तो 9 शेड्यूल अभी न्यूज में क्यों था? बेसिकली देयर वाज सम डिमांड्स फॉर दिस, ये जो रिजर्वेशन प्रोविजन है SC ST OBC का, सो मेनी ऑफ द कम्युनिटीज वर डिमांडिंग दैट दिस शुड बी पुट इन 9 शेड्यूल, क्योंकि अभी रिसेंटली बहुत सारा चेंजेस हुआ है, सुप्रीम कोर्ट हैड सेड समथिंग, तो इस इन दिस कंटेक्स्ट वी आर सेइंग दैट दिस शुड बी, ये जो 9 शेड्यूल है अभी न्यूज में था. सो लेट्स जस्ट ब्रीफली सी दिस, व्हाट एग्जैक्टली इज दिस 9 शेड्यूल. So this 9 schedule was introduced under the first Constitutional Amendment Act 1951. Okay, first Constitutional Amendment Act 1951, which among the many other changes कल भी हमने देखा था. So this is among the few changes which are brought. So first thing is it introduced Article 31A. And the second thing, it introduced Article 31B. Article 31A. Let's talk about this. Article 31A says there are 5 categories of laws. Now 5 categories of laws cannot be questioned by the judiciary. So basically, if these laws are implemented for the purpose of acquisition of plantations or property, or in case of ये जो distribution of properties or land वो करने के लिए हमने दिया था, in that case, if the government is bringing laws, so that cannot be questioned for the violation of fundamental rights under Article 14 and 19. Okay, in that case, you cannot question. Okay, these 5 categories were given in Article 31. Okay, so basically it is saying that if at all there are any laws in these 5 categories, that cannot be questioned for violation of Article 14 and Article 19. That is Article 31A. There is also Article 31B. So इसके अंदर तो 5 categories दिया था, ये तो पूरा open है. Okay, this is completely open, saying that whatever the laws, the government wants to put it in a separate schedule, and that separate schedule is 9th schedule. The government wants to put any particular law in 9th schedule, that cannot be questioned for violation of any of the fundamental rights. And because fundamental rights have some certain kind of provision, certain kind of status in the Indian Constitution, if at all there are any laws for the violation of fundamental rights, that can be clearly questioned in the court of law. So इसलिए जो भी law, if you think that the people can question this law for the violation of fundamental right, that can be put under 9th schedule and the court will not interfere. These were the original provisions introduced in the first Constitutional Amendment Act 1951. Okay, 31A and 31B. 31B has the provision for 9th schedule. So मतलब the government, if whatever the parliament decides that ये जो law हम बना रहे, the Supreme Court should not touch, saying that ये violate हो रहा है, वो हो रहा है, ये हो रहा है, तो ये सब issue headache नहीं होना चाहिए हमें, तो इसलिए हमें we are putting in the 9th schedule. Okay, so but this blanket ban on the judicial review was removed by the very famous IR Coelho case. IR Coelho versus the state of Tamil Nadu in 2007. इसके ऊपर UPSC का भी क्वेश्चन आया था कि this blanket ban was removed, saying that you are saying judiciary cannot interfere at all. ये गलत है. Okay, ये गलत है. So now the question of judicial review came. तो उसका मतलब है तो judicial review, can they do judicial review of any law? No. So in this case, the Supreme Court said that whatever laws made by the government or the parliament after 1973 are open to judicial review, even if they are under the 9th schedule. है ना? तो even if they are put under 9th schedule, they are open to judicial review. And what grounds they can be checked? If at all they are violating Article 14, Article 15, Article 19, Article 21, or the basic structure. If they are violating any of these things, in that case, the Supreme Court can check whether they are valid or not, even if they are in the 9th schedule. Okay, this was said in IR Coelho case. Now, why after 1973? Because 1973 is the year which gave the verdict of Keshavananda Bharati case. Keshavananda Bharati case, which brought the concept of basic structure in the Indian judiciary. Okay, in the Indian constitution. तो बेसिकली जो 1973 उसके पहले है तो ठीक है, तब तो बेसिक स्ट्रक्चर का कॉन्सेप्ट नहीं था, अभी तो है, तो you should not have made this provision. So if at all this is violating the basic structure का जो भी basic feature है, if it is violating, then this can be questioned by the judiciary, even if it is violating, even if it is put in the 9th schedule. That has been said by the Supreme Court in IR Coelho case. case. बाकी करंट न्यूज तो इसमें ज्यादा नहीं है, right? So there just demands that these legislation should be put, but we should understand that there is no such protection, blanket protection. तो अभी रहा नहीं. Any doubts here?
No, sir.
Hello, sir.
Yeah.
I have a small doubt. Sir, can laws passed by state legislature can also be put there in 9th schedule?
And that would be put by the parliament only.
Okay.
Yes. It would be placed in the 9th schedule by the parliament only.
Okay. Thank you.
Yeah. Now the next topic number 1.5. Okay, overseas citizenship of India. That's 1.5, right? Yeah, 1.5. Overseas citizenship of India. So recently there were some news related to overseas citizenship of India. Government had clarified that they do not enjoy fundamental rights. They have fundamental rights. ऐसे बहुत कुछ confusion था. Let's just clarify this. So before we go to that, let me just briefly explain about the provision related to citizen. I'll just take a few minutes about this. So basically in India, whoever the people residing or the people currently in India, they can be categorized into two groups. One is citizen of India. Another one is, you can say, aliens. Okay, aliens का मतलब ये नहीं कि they are coming from outside the earth. Basically, they are the people referred who are not the citizens. Okay, in that aliens, there are two categories. One is friendly aliens. Another one is enemy aliens. Fine. So these are the categories. Friendly aliens. Friendly aliens का मतलब है these foreigners who are visiting in India, the citizens, non-citizens who are visiting India and they are in India currently. Okay, they are friendly aliens. The enemy aliens तो पता है जो enemy countries which we refer to spy हो सकते हैं. So they are considered to be enemy aliens. Now, which kind of fundamental rights are available to these people? Okay, all the fundamental rights, जो भी fundamental rights are guaranteed in the Indian Constitution from Article 13 to Article 31 तो नहीं है 32. Okay, these are the fundamental, or all of them available to citizens or any of them available to alien, ये सब देखना है. So there are certain fundamental rights which are available to citizens. Okay, only citizens. Okay, so these are the fundamental rights which are not available to alien, any alien, friendly alien को भी नहीं है, even enemy alien को भी नहीं है. These are the fundamental rights. Fundamental rights under Article 15, Article 16, Article 19, Article 29, and Article 30. So these are the 5 fundamental rights available only to the citizens of India, not to anyone else. Non-citizens cannot claim even if they are friendly aliens. Okay, in addition to this, the right to vote, right to contest elections, right to hold public office, and even the fundamental duties. The government compelling anyone to follow the fundamental duties, that can be done only for the citizens. This cannot be asked to do the same by the aliens. Okay, इनके लिए allowed नहीं है. बाकी सारा friendly aliens के लिए allowed है. This has been even confirmed by the Supreme Court. But except this, there is one article which is not available to enemy aliens also. That is Article 22. What is Article 22? The right against this illegal detention. So that is what is Article 22. So that cannot be raised by enemy aliens. Fine. I hope this is clear. Now let's come to overseas citizenship of India. Overseas citizenship of India. Who exactly is overseas citizenship of India? We have 3 categories. एक तो मैंने बोल दिया citizens, है ना? Citizens के अंदर there are again 2 categories who are residing in India, who are not residing in India. Okay, they are called as NRI, non-resident Indians. They are the people who are not in India, but they are still the citizens of India. They are staying in other countries. Okay, they are in other countries. They are called as NRI. And friendly aliens के अंदर there are many other categories. Maybe foreign visitors हो सकते हैं, tourists हो सकते हैं, but there are few categories which is said to be, these are the people who had some connection with the India's historically, their parents would have been citizens, तो उनके लिए थोड़ा सा special recognition देना चाहिए. इसलिए we have the classification of overseas citizenship of India and there is also persons of Indian origin. Pehle these two were separate, now these two are merged. Persons of Indian origin as well as overseas citizenship of India is same. They have some special considerations, some special categories, some special benefits would be given to them. So who are these overseas citizenship of India? Okay, so there is this so there's this definition which, as per the Overseas Citizenship Act, which says who are the overseas citizens of India. It is saying that people who is a citizen of another country but was a citizen of India at the time of independence or any other time. Okay, at the time of commencement of the constitution or any other time, for some period he was the citizen of India, but now he is not a citizen of India. He can become an overseas citizenship. Or he is a citizen of another country but was eligible to become the citizen of India at the time of commencement or later. Now, मतलब उसके पास eligibility था, but still he chose to remain not to take up Indian citizen. He can become overseas citizenship of India. The third one, and he is a citizen of another country but belong to the territory that became part of India. मतलब there can be maybe some territories were acquired, but the government gave the option that maybe those people may not want to become citizen of India, they can remain so. Okay, they had the choice of becoming citizen of India, but they did not choose. They are not. They also can choose to become an overseas citizenship of India, or any of their child, children, grandchildren, great grandchildren. So उनका जो भी family tree है, they all can become the overseas citizenship of India. So what exactly is this overseas citizenship? It is based on the provision of Citizenship Act 1955. Using this, we have given certain benefits for them. Okay, for them to encourage to keep their links with the India. What are the benefits? They have multiple entry, multi-purpose, lifelong visa. Okay, they don't have to apply for the visa separately. They are not required to enter only through certain airports, or they don't have to renew the visa facility. Okay, they have lifelong visa, multi-entry, multi-purpose. For any purpose, they can come and go anytime. This is one of the benefits. But what is not guaranteed? They don't have the voting rights. They cannot hold a government job, and they cannot acquire plantation or agriculture property. Okay, these rights are not given to them. Even though they can visit India, they cannot have the voting rights, they cannot vote here, they cannot hold a government job, and even they cannot acquire agriculture or plantation property, but this provision is given for NRI. Okay, I hope this is clear. We know about this, who exactly are these overseas citizenship of India. Now come to the next question. What exactly has happened? Recently, क्या issue था? Earlier, the Supreme Court has confirmed that whoever is a friendly alien will enjoy any of the fundamental rights except this. ये जो 15, 16, 19, 29, 30 है, और even the right to vote, contest public office and fundamental duty है, इसके अलावा जो भी fundamental rights है, so that can be exercised by any of the friendly aliens. In that, we also know that OCA is included. This has been confirmed by the Supreme Court. This also has been confirmed by the Delhi High Court in 2018. But recently, one of the overseas citizenship of India had asked two questions to Delhi High Court. One is, this OCA, do they have the right to file RTI? Do they have the RTA? Second one, Article 25. Do they have the right to practice one's own religion? ये जो religious freedom है, is it available? But based on the previous 2018 judgment of Delhi High Court, so this Article 25 तो होना चाहिए, क्योंकि ये तो इसके अंदर नहीं आते. But RTI, what about RTI? RTI नहीं आएगा because RTI comes under Article 19. Okay, and RTI is only for Indian citizen. So in this case, again freshly the Delhi High Court asked the central government, आपका क्या इरादा है इसमें? What is your opinion? In this, surprisingly, the central government said that overseas citizenship of India, OCA जो भी है, इनके पास there is no fundamental rights at all. Okay, whatever the rights we are guaranteeing other than this, they are not fundamental rights, but they are statutory rights. Statutory rights provided through Overseas Citizenship Act. Okay, this has been said by the central government. It has been clarified by the central government, but it did not say about the right to freedom of religion. ये जो बाकी सारा rights है उसके ऊपर क्या होगा उनका, that is not clear right now. Okay, let's hope that this will be clear in the future. But ये तो confirm है, this OCA is not available for sorry, RTA, the right to file RTA is not available for any other non-citizens. But other than this, Supreme Court and High Court has said that jo bhi other than these rights are there, that should be made available. Fine. Any doubts here?
No, sir.
Yeah. Next one. 1.6, UN not a state. Okay, this is a simple topic. So basically कुछ एक केस फाइल हुआ था saying UN के ऊपर केस लगाना है तो कैसे करना है and all. तो इसलिए the High Court has clarified that some things about the definition of state. Before we go to that, let's just briefly see this. What exactly is the definition of state? The definition of state is given under Article 12. Article 12 comes under Part 3 of the Indian Constitution, which talks about the fundamental right. Okay, so यहाँ पर definition of state क्यों चाहिए था? Because the fundamental rights are those rights guaranteed against the state. That means if at all there is any violation of these rights by the state, the state can be questioned in the court of law. And for that purpose, there should have been a definition of state. Isliye it has been defined in Article 12. So what exactly is the definition of state under Article 12? It says that Union Executive and Legislature, State Executive and Legislature, local authorities, other statutory and non-statutory authority, any other body of the government of India या उसके order के ऊपर जो भी बना हुआ है, so that becomes the definition of state. That is legislature, executive, as well as the local bodies, including the statutory and non-statutory bodies. All these come under the definition. Now my question is judiciary. What about judiciary? Do they come under the definition of state? So there had been very confusing arguments regarding this, whether judiciary should come under the definition of state or not. Even this has been clarified by the Supreme Court in many of the cases, and in few of the cases, even the Supreme Court judgment itself is confusing. But now the current stand is that if at all the judiciary is acting as the court itself in its judicial powers, if at all the judiciary, the courts are exercising their judicial powers, in that case it will not come under the definition of state. But in case of non-judicial powers, in case of administrative powers, while exercising administrative powers, if at all maybe the court is making any rules or regulations, in that case it will come under the definition of state. Okay, that means जो भी कोर्ट का जजमेंट होगा या जो भी द जुडिशियल कैपेसिटी में काम हो रहे, in that case nobody can question the court saying that this is a violation of fundamental right. Fine, it's only in the administrative capacity the judiciary become part of the state. Now come to the UN. Okay, United Nations Organization के बारे में हम पता है, तो somebody had asked whether this comes under the definition of state or not. इसके अंदर तो क्लियर है, यूनियन एग्जीक्यूटिव इट्स नॉट द स्टेट एग्जीक्यूटिव, इट्स नॉट द लोकल अथॉरिटी, इट्स नॉट देयर, इट्स नॉट a statutory, non statutory body. The Delhi High Court has clarified that UN is not a state under Article 12. So what is the meaning of this? If at all there are any violation of the fundamental rights by UN, you cannot go to the court under Article 32. Okay, UN का ये action has, this action of UN has led to the violation of my fundamental right, so please you provide some benefit, some relief for this. ऐसे आप नहीं पूछ सकते हैं. So UN is like any other body. So another question is whether it is a foreign state or not, है ना? So even the Delhi High Court answered this also, saying that UN is not a foreign sovereign state also. है ना? It is neither an Indian state, it is not coming under the definition of India state, nor even the definition of foreign states. है ना? इसका क्या implication है? If at all any person wants to file a legal suit, okay, against any of the foreign state, in that case, as per Civil Procedure Code (CPC), the permission of central government is required. Then only you can initiate a legal suit against any of the foreign state. But here there is no need of a permission of central government if at all any of the persons are initiating a legal suit against UN. Okay, this is the implication of this. Any doubts?
No, sir.
Okay. Last thing. Okay, in the end of this section, there are few articles which are given over there. I just want to highlight it that the articles which are currently in news. Article 87 refers to this special address by the president, which talks about the legislative and policy proposals at the beginning of every session. Okay, this is the budget session. At the beginning of this budget session, the first address will be by the president. That power is under Article 87. Okay, next one, 164. 164 talks about administering the oath of office and secrecy to minister. Okay, oath of office and secrecy to the minister. So this comes under third schedule of the Indian Constitution. So that is recently in news. बहुत लोग ऐसे oath के इसमें issues था, तो इसलिए था. And third one, Article 340. Article 340 is also important. So that talks about the power of the president to appoint commission to investigate the conditions of backward classes. Okay, president can appoint a commission to investigate the condition of backward classes. Recently, there is this committee, Justice G. Rohini committee was appointed to see the backward classes ka condition. So that is why it is in news. Try to remember this name. Justice G. Rohini committee was established to look into the backward classes. उसके अंदर specifically ये जो अभी all India level पे categorization है backward classes, there is no different categories inside the OBC. In states, there are different categories inside the OBC. Some of the categories are considered to be more backward, some of them are less backward. जैसे categories अभी करना चाहिए नहीं करना चाहिए वो decide करने के लिए this committee has been appointed. And we know about this Article 371 to 371J. This provides for special status to many of the parts of the states, and that was recently in news. So इसलिए this has been mentioned. Just remember the articles. UPSC has started to ask a few specific articles. इसलिए we have given this at the end. Just go through this. Okay, that completes the first section. Okay, I wanted
one thing, sir.
Yes.
Yes, a previous class से related है, sir. The query is that the Supreme Court had stated that the reservation is not a fundamental right. So does this mean that the states, states exercise some kind of discretion in awarding the reservation?
No. It's not about the discretion. It's about whether to give the reservation or not. Okay, discretion is not related to give reservation to some and to give reservation not to give some to someone else. यहाँ पर discretion नहीं है. It is about the state decision to whether give the reservation or not. If the state is deciding हाँ हमें देना चाहिए, so in that case it's fine. If the state is deciding thinking that we don't have to give the reservation, nobody can question the state. You cannot go to the court and say asking them ये हमारा violation of fundamental right है. Usually जो भी fundamental right के अंदर provision है, if at all it is violated, you can directly go to the court. So in this case you cannot come to the court saying that our fundamental right is violated. Okay, that is the meaning of this. It's not about the discrimination between different sections.
Okay, sir. Thank you, sir.
Okay. Any other doubts?
No, sir.
Okay. Fine. Yeah.
Yeah, sir, I have received a query and I'll just read out exactly as the student has written.
Yeah.
Article 330 provides for reservation of seats for SC/ST in Lok Sabha. Is there any provision in Constitution for reservation of seats in Rajya Sabha? And the second question is Article 15(4) provides for reservation of seats for backward class in educational institution. Does this provision extend to the private institutions also? And
okay, let me answer the first one.
Yeah.
So there are no such reservation as such in Rajya Sabha. Rajya Sabha is members are indirectly elected and there is only nomination facility. Okay, 12 members are nominated as such, but reservation there is no representation as such in Rajya Sabha. What was the second question?
So Article 15(4) provides for reservation of seats for backward class in educational institutions.
Yes.
Does this provision extend to the private institutions also?
Yes. Private, both aided and unaided, except the minority institutions.
Yeah, sir. Third question is, sir, does the Constitution define the word SC, ST and backward classes?
So it's not defining as such. It's not defining any of these backward classes also, but this is usually done by the commission, जो National Commission for Backward Classes है, and they would be recommending who are the communities which should come under the backward classes and all. And but when it comes to ST and SC and ST, the communities would be declared. So if it is passed in the parliament. Currently it has to be passed in the parliament क्योंकि first list जो बनेगा that would be by the president in consultation with the governor. Once the first list is done, that is immediately after the independence जो first list बन गया था, उसके बाद में जो भी changes लाना चाहिए, if you want to add sub communities to SC/ST group or if you want to remove them, that has to be passed in the parliament. There is no definition as such. So this would be completely by their the working, how their living conditions are there, how the nature is there.
Okay, so just one more question. So are the nominated members eligible for becoming ministers? Can they be made ministers?
Yes. Nominated members can also become minister, and in fact, any person who is even not even elected can also become minister.
Okay, sir. Thank you. Done, sir.
So any other queries?
No, sir.
Is there a query?
No, sir.
Okay. Fine. We took more than enough time for the first section. This was related to the constitution. That's why some detailed discussion was required. So I was thinking of starting with the second section also, but we have exceeded the time given to us. So we'll continue tomorrow. Okay. From tomorrow we'll try to fasten it up. क्योंकि बाकी सारा जो भी इशू है एक्सेप्ट जुडिशरी में विल ट्राई टू एक्सप्लेन इन ब्रीफ. तो रेस्ट अदर देन दैट wherever there is no static portion, wherever we are talking about the current affairs only, we'll try to fasten this. Okay. We will stop it here. We'll continue tomorrow. Thank you.
Thank you.